Good afternoon, everyone. My name is Marcelyn Burke, and I'm the Dean of Tulane Law School, and it is indeed my great privilege and pleasure to welcome you to the William Tetley Lecture in Maritime Law. The Tetley Lecture honors a towering figure in maritime law with special ties to Tulane. Professor William Tetley led not one, but 3 distinguished careers. A graduate of McGill University and the Laval Faculty of Law, Professor Tetley first built an acclaimed career as a practicing lawyer. Practicing for nearly 20 years with one of Canada's premier law firms, Professor Tetley attained the rank of Queen's Counsel in 1968. Professor Tetley then transitioned into a high-profile career in government service, ultimately as a member of the Quebec National Assembly and as a cabinet minister. It was only at this point, a quarter century into his professional life, that Professor Tetley launched his career as an academic, saving the best for last. He joined the faculty at McGill University in Montreal, and over the next 3 decades, Professor Tetley established himself as one of the world's leading scholars in maritime law. For 15 years, from 1984 to 1996, Tulane Law School was fortunate to count Professor Tetley as one of our own. During that period, as a distinguished visiting professor, Professor Tetley annually traveled to New Orleans, as he put it, going south each winter like a Canadian goose, to teach a course here at the law school where he was beloved by students and colleagues alike. In 2001, the law school created this lecture series in Professor Tetley's honor. Somewhat unusually, the lecture series was created without an endowment to support it. I don't want to say who the dean was then, but that would not happen today. But simply as a tribute to a colleague who has greatly enriched our community, our students, and the entire field of maritime law. 10 years later, in 2011, upon learning this fact, however, Professor Tetley himself made a generous gift to endow this lecture series into perpetuity, and we are forever grateful. Tulane's tribute to an eminent scholar and dear friend was thus returned, demonstrating again just what a special friend he truly was. Through the years, the Tetley Lecture has attracted leading figures in the maritime field from around the world, in academia, industry, government, and legal practice. Today, we are truly privileged to continue this tradition by welcoming Ann Fenech from the Comité Maritime International as our speaker. And to introduce our distinguished speaker, I will now turn the podium over to our own Martin Davies.
Thank you very much, Dean. Before I introduce Anne, I want to share a little story about Bill Tetley. Bill used to come down to witness the lecture until he was not physically able to travel anymore. And he would always give a vote of thanks at the end of the lecture to the speaker, which those of you who knew Bill will know that Bill's vote of thanks was usually like his description of all the things that he disagreed with about what the speaker had said. And there's a kind of note of correction at the end from Bill. Right? And the first year that Bill couldn't come, we fixed up a telephone link. Bill listened to the lecture, not through Zoom. This was before the days of Zoom. And Bill was sitting in his office at McGill, clearly with someone else, because Bill would comment during the lecture on what the speaker was saying to this person, whoever it was in the room. Now, why? If you look up, there are speakers and Bill's voice came through like the voice of God, right? Oh no, that's not right, right? I won't tell you which speaker it was that Bill was disagreeing with, but anyway, enough about Bill. You have a picture of him in the program here. That little pin on his lapel, by the way, is the Order of Canada. And Bill died on Canada Day. It's very appropriate. Well, no, it's not appropriate that he died at all. You know what I mean, right? But my task is to introduce Ann Fenech. There is an extensive biography in the program, so I'm not going to repeat everything that it says in there. Anne is the president of the Comité Maritime International. I would tell you what the CMI is, but I have a feeling that Anne is about to tell you what the CMI is and does. She was instrumental in seeing through to adoption the recently made International Convention on the Recognition of Judicial Sales of Ships. She's also going to tell you about that. So I'm not going to steal her thunder about that either. I said the biography of Anne is here in your material, but I did want to draw your attention to one thing. Again, I'm hoping that I'm not telling you things that Anne is about to tell you. But if you look, she started her career in London at a firm called Holman, Fenech and Willen, which is still going. And if you look on the back of the program, you'll see that the Tetley Lecture in 2003 was a man named Archie Bishop, the late Archie Bishop. And Archie was Anne's mentor and found her a position, or at least so she tells me, with Chaff McCall here in New Orleans. And Anne and her husband, Thomas, lived here for 2 years practicing at Chaff. I could go on. Anne is a past president of the Maltese Maritime Law Association, and can't be both that and the president of CMI. So anyway, enough from me. Without further ado, Ann Fenech. Thank you.
Well, good afternoon, ladies and gentlemen, dear students, dear friends. Peter here. We were together at Chaff, so I'm so happy to see you here this afternoon, Peter. I would like to start by thanking Martin Davies and, of course, Madame Dean of the Faculty of Law and Tulane University Law School for inviting me to give this very prestigious lecture here today. I feel immensely proud and honored indeed by this great compliment as the president of the Comité Maritime International. I know that a number of past presidents of Comité have actually given this lecture here before me, like Professor Berlingeri, the famous Francesco Berlingeri, Patrick Griggs, and Stuart Hetherington. But for me, it is particularly special, and as Martin has already said, and given you some inkling, this, of course, is not my first visit to New Orleans, because in 1990, I returned home one day from work, and work in those days, as Martin said, was London. And my husband, an ophthalmic surgeon, we were both very young then, working his way up the NHS ladder, announced that he had been given an opportunity to do a retinal fellowship at Tulane Medical Center. And he said, shall we go? I also happened to be pretty heavily pregnant then, but I promptly said, yes, of course, because I like a challenge and I like a bit of excitement. And so the following day, I went to the office, which was HFW, and I went up to Archie Bishop's office. He was the managing partner at Holman's then. And I said, Archie, I said, Thomas has been offered this opportunity to go to New Orleans. What should we do and what should I do? And how do I go about getting a job? So he said, in typical Archie fashion, he was a world authority on salvage, the doyen of salvage law. And he said, hang on a minute, sit down, Anne, picks up the phone, calls Bob Dean of Chaff McCall, and before I knew it, Chaff's had a desk and an office waiting for me, because that was the way things were done in those days. So in August of 1991, Thomas and I and our baby boy, Matthew, because he was born by then, 6 months, made our way to New Orleans, and I started to work at Chaff's as a foreign attorney. I still have my card saying Chaff, McCall, Phillips, Stoller, and Sarpi, foreign attorney, where I was exposed to every conceivable wet situation known to man. I was flabbergasted by the volume of cases, the amount of collisions, pilotage, towage, salvage, and all manner of interesting real-life maritime cases, which the magnificent Mississippi has a habit of providing, that I was totally engrossed, I was totally absorbed and thankful indeed for the opportunity. So today, 30 years later, I would really like to publicly thank the late Rob Fisher, Bob Dean, and the very much alive Dwight LeBlanc, who I met yesterday, for this marvelous opportunity which they gave me and which contributed significantly to this passion which I have for the maritime space, and particularly for wet work, which is still my favorite. In my day job, I do cover all aspects of marine litigation. We had to pick up Martin's book on shipping law and sort of go like this. My office in this itsy-bitsy island of Malta deals with every possible, conceivable aspect of shipping law. But it's the wet side of shipping that gets me really excited. Now, as president of the CMI, I now look back at my various work traveling experiences and try to ensure that in my day-to-day work at the CMI, those experiences are put to good use. And whether it is for the purposes of understanding the different ways in which various jurisdictions tick, or whether it is for the purposes of understanding the minds of the people in those various jurisdictions, whether it is for the purposes of ensuring that in the intense deliberation of a maritime issue, likely to have international repercussions, that we do not leave that negotiating table without reaching consensus. These are really important things I have picked up on the way. What my various travels have certainly taught me is that what clearly spurned the forefathers of the Comité Maritime International to create the Comité still exists today, making the CMI, I firmly believe, more relevant today than ever before. And I hope that by the end of this lecture, you will agree that 127 years after the creation of the CMI, we still need the CMI more than ever before in our quest for the unification of international maritime law, which to this day remains the raison d'etre of the Comité, and that the CMI today remains one of the major catalysts on the stage of international maritime law. Now, about the roots of the CMI, and here I would like to beg the forgiveness of those who know more about the CMI than perhaps the students here at Tulane, but I feel I really need to explain a little bit of background. Now, every time I'm asked to speak about this subject in particular, I search high and low for a different definition or quote or reference to make the point. However, notwithstanding my continuous searches, I feel I need to fall back on the quote from Albert Lillard, who was the president of the Comité between 1947 and 1976. I don't think anybody said it in any better terms, so I'm going to repeat it. And Albert Lillard said this: "The history of maritime law bears the stamp of a constant search for stability and security in the relations between the men who commit themselves and their belongings to the capricious and indomitable sea. Since time immemorial, the postulate which has inspired all the approaches to the problem has been the establishment of a uniform law." Now, going back to the founding fathers of the CMI in 1897, Louis Frank, he's quoted as having stated, "It is with the object of overcoming multiple opposition, national particularism, of resolving difficulties, not by means of abstract and theoretical solutions, but from the needs of practice, of obtaining the ear of the parliaments, that we had the idea of appealing not only to the jurists who are interested in maritime law, but to the very people who, in their interests, in their problems of every day, have to submit to the consequence of good and bad laws. We have taken into consideration that the ship owner, the merchant, the underwriter, the average adjuster, the banker, the person who is directly interested, all take a preponderant part in our work. That the task of the jurist is to discern that which, among those divergent interests, is common to all. To discern what, among the diverse solutions, is the best to contribute one's learning and one's experience. But that in the final analysis, the jurist must hold the pen, and that it is the man with the experience who must dictate the solution. And I think, you know, Mr. Frank said that in 1897, and I'm sure we all agree that it's still valid today. So the Comité was created in 1897 with 8 founding members: Belgium, Denmark, France, Germany, Italy, the Netherlands, Norway, and the United Kingdom. Today, we have 57 national maritime law associations, members of the CMI, because the members of the CMI are the National Maritime Law Associations. One of my wishes since I've become president in 2022 was to have 1 new member every year. And since 2022, in 2023, we welcomed Bangladesh. And in 2024, we welcomed the United Arab Emirates. So we just need to wait and see what 2025 has in store for us. Now, over the years, the CMI has been responsible for drafting the vast majority of international maritime conventions. The Collision Convention of 1910, Salvage Convention of 1910, followed by the one of 1989. In the area of carriage of goods by sea, the Hague-Visby, the Rotterdam Rules, limitation of liability conventions, the oil pollution conventions, maritime liens and mortgages, stowaways, HNS, all the arrest of ships, Athens Convention in relation to carriage of passengers, and a host of others. A few words on how the CMI actually works, this Comité Maritime International made up of 57 national maritime law associations. Well, the fundamental basis supporting the modus operandi of the Comité has remained the same, while at the same time, most importantly, the Comité has ensured that it embraces developments in the law, changing landscapes, and new technologies, while implementing the necessary positive changes, ensuring it remains au courant. However, from the early days, it would create international working groups tasked with studying a particular problem with a view to understanding it and concluding whether it will be of benefit to have a convention in that particular area. So once the IWG would be created to study something, the IWG would normally issue a set of questionnaires and send it out to all the national maritime law associations around the world. And in this way, the national maritime law associations would reply to the questions, giving the views of that particular jurisdiction. Armed with academics and leading practitioners from a variety of nations, the CMI, therefore, has the ideal human resource to analyze a situation and make recommendations either for a convention or no need a convention. Now, this is to this day still the modus operandi of the Comité. And more than ever before, the model remains a robust and certain model, bringing to the table practitioners and persons with the necessary academic background, as well as the practitioners and industry, very frequently at the coalface of real-life situations, which we all study as students, but which all have a real-life effect, enabling them to identify the challenges and offer solutions that work. Solutions that work. So today, in fact, as we speak, there are no less than 7 CMI projects going on at the same time. We've got questionnaires to all the NMLAs at the moment going out on the Lex Maritima, decarbonization, maritime autonomous surface ships, MAS, collisions, seafarers, Rotterdam rules, and mobile offshore renewable units. However, the Comité was and remains a private organization. We can draft the conventions, we can make suggestions, but it is not itself a legislative body. So in the early years, we're talking about when CMI was created in 1897, the Comité would operate through the medium of the Belgian government. The CMI would come up with a convention, and it would present it to the Belgian government. And the Belgian government would, in turn, itself call a full diplomatic conference and would deliberate the draft, amend and discuss, and at the end, there would be a convention under the auspices of the Belgian government. And this continued until 1968, when the last Brussels conference was held. Now, in actual fact, the 1960s radically changed this Belgian model insofar as the promulgation of conventions was concerned. 1967 was a very important year because it saw the major oil spill from the Torrey Canyon. And as a direct result of the Torrey Canyon, the Intergovernmental Maritime Consultative Organization, the IMCO. Can anybody tell me what the IMCO is today? It's the IMO. This was the old name for the IMO. Well, actually, because that is what the IMO was called when it was created in 1948, formed the legal committee. So in 1967, after the Torrey Canyon, the IMO formed the legal committee. And the legal committee was tasked with producing a convention which would deal with liability for damages caused by oil pollution from tankers. Now, the CMI played a key role in the drafting of this convention. It was a CMI convention. Meanwhile, in 1964, the United Nations created UNCTAD, the United Nations Conference on Trade and Development. And in 1966, the UN created UNCITRAL, the United Nations Commission on International Trade Law. Now, what does all of this have to do with the CMI and Belgium? So after the creation of the legal committee at the IMO, UNCTAD and UNCITRAL, rather than go through the Belgian government, thereafter, CMI started to present its work to these UN institutions. With the creation of the legal committee of the IMO in 1968, the CMI was, until 1979, responsible for the initial drafting of every single convention considered by the IMO. The relationship between the CMI and the IMO remains very, very special, with the CMI being the first NGO to be granted consultative status with the IMO. And this enables the CMI to participate in the various committees, particularly the legal committee, where the work output for potential legal projects is actually discussed. And this is the forum now. The legal committee of the IMO is the forum where the CMI proposes its drafting ideas, and the forum where the CMI joins others in their efforts to promote international maritime law. The legal committee of the IMO meets once a year. And in fact, the next meeting will be on the 24th of March, your birthday, Tom, 2025. We've had loads of IMO conventions which were drafted by the CMI, the Athens Convention, the Limitation of Liability Conventions, the Salvage Convention, and a host of others. Now, other UN institutions have, over the years, also adopted CMI drafts. Because although the legal committee of the IMO would be our first port of call, there would be other more appropriate UN institutions to actually legislate the work of the CMI. And that has included UNCTAD, who were the ones that promulgated the International Convention on Maritime Liens and Mortgages, and the Arrest of Ships Convention. All the Arrest of Ships Conventions were UNCTAD documents. And UNCITRAL, which produced the Rotterdam Rules, and our brand new, spanking new convention on the international effects of judicial sales of ships. So, what about the current work of the CMI? In 2014, just over 10 years ago, a previous president of the CMI, Stuart Hetherington, stood here, probably at the same podium, Martin, I would think, at Tulane, giving the Tetley Lecture. And his lecture was entitled, you see, I've done my homework, "The CMI and the Panacea of Uniformity. Is this an elusive dream?" he asked. In his lecture, he stated, and I quote, "Uniformity may be fleeting because trade and commerce constantly change and require new rules and procedures. Nevertheless, there is no doubt that greater uniformity in liability regimes and commercial documentation around the world makes it easier and cheaper for traders to operate. The panacea is indeed elusive, but we should not give up our pursuit, he said. So what I can certainly say here, standing after him for 11 years later, is that the CMI continues to identify areas which could be of great benefit to the entire maritime community, including its maritime traders. And over the past 10 years, we have seen extraordinary developments, both of a geopolitical and technological nature, and I would suggest that the need for the CMI has never been more acute. Maritime automated surface ships, artificial intelligence, digitalization, the physical threats to shipping, and therefore to the very well-being and safety of our crews, and the very severe challenges to maritime operators, unless there is a genuine attempt at finding appropriate solutions, including unifying the laws of different countries, so we can all sing from the same hymn sheet. This has never been as important as it is today. I would like to draw on the wise words of Judge Charles Haight of the United States District Court for the Southern District of New York, who delivered the Haley Lecture in New York University School of Law in 1996, and who said, "Those who strive to achieve a uniform maritime law, nationally and internationally, seek to have the people, the maritime community, ship owners, cargo owners, insurers, lenders, furnishers of supplies, salvors, be of one language and of one speech, so that rights and obligations may be certain and predictable." It's worth pointing out that the words "be of one language and speech" are from the great book itself, Genesis. So really, we've all been saying the same thing. The importance behind the uniformity of international maritime law is essential. Maritime law and maritime trade is the epitome of international law, really and truly. One look at the agenda of the IMO Legal Committee held in April of last year is sufficient to give us all a good idea of some of the current issues which are the subject matter of intense discussion. Fair treatment of seafarers, particularly in the case of abandonment, and when detained on the suspicion of committing a maritime crime. Measures to prevent unlawful practices associated with fraudulent registries of ships, piracy and armed robbery against ships, decarbonization, liability, etc. These are all, and also, so the IMO is working on these, with all of these issues high on its agenda as we speak. And I'm delighted to say that our schedule at CMI is running in parallel with this to offer support. Our IWG on decarbonization, and I'm particularly proud of this international working group because we set this up last year under the chairmanship of Haris Zografakis, who is a leading authority on liability and decarbonization, has made very good progress at our Gothenburg colloquium in May of last year and produced, under the Green Fuels workstream, a paper on liability and compensation regimes for incidents on board vessels involving the carriage or consumption of alternative fuels. Because you may be interested to know that at the moment, all the limitation, liability regimes, etc., don't really deal with the liability of ship owners resulting from the carriage of non-fossil fuels. So here we are, the entire planet's talking about decarbonization, but there's a very important issue which needs to be dealt with, and it's on the IMO agenda and very much on the CMI agenda. In fact, just at the end of the year, the CMI, just a few weeks ago, was invited to co-sponsor a work output proposed by the Australian delegation at the IMO on liability in decarbonization, which is expected to be deliberated at Leg 112. And in fact, the paper has only been put up on the IMO website, if any of you are interested in this really, really interesting area of maritime law, last week. And if you go into Leg 112, you will find the agenda and you will find all the papers there. So we've done work on that. We've done work on liability in relation to automation, You know, we're all talking about mass and automated vessels. What about liability? Who is going to be liable when something happens? Now, we put that on the IMO agenda last year. There's an excellent paper on liability prepared by the CMI, but the IMO said, we'll hold on to discussing that for now. Let's see what the technical committee of the IMO come out with regarding the mass code, what they are referring to as the mass code. Once the mass code is out, then we'll start to talk about liability. Another important project currently being undertaken, and this is very really hot off the press, is the work on mobile offshore renewable units. And I know that the American Maritime Law Association, US Maritime Law Association, has a number of representatives that are very active in this working group. And all of these are going to be really hot topics for our colloquium, or rather conference in Tokyo in 3 months' time. However, what is hot off the CMI press, and which truly encompasses the raison d'etre of the CMI, how the CMI rises to the occasion, identifies issues which need to be dealt with, and then interacts with international organizations, is of course none other than our recently adopted and signed off Convention on the International Effects of Judicial Sales of Ships. I say this with a smile on my face because it took 5 years of my life, which I enjoyed and which I would do all over again. The convention was adopted by a resolution of the General Assembly of the UN on the 7th of December, 2022. And the pace with which the CMI Beijing Convention was negotiated, deliberated, agreed, and adopted by the United Nations in 3 years, has taken even the most seasoned convention circuit participant and observer by surprise. Now, so what's this convention and where did it come from? It was Professor Henry Lee from China who in 2004 reported to the CMI that there were numerous cases where the free and unencumbered title given to purchasers of ships in judicial sales was not being recognized in other jurisdictions. So he spoke of instances where, notwithstanding the clean and unencumbered title given to purchasers, creditors of previous owners would rearrest the vessels in the hands of the new owners, where states failed to recognize judicial sales in other jurisdictions, where purchasers came across significant obstacles in getting the old mortgages registered against the vessel prior to the sale being deleted, where the flag state of the vessel that had been sold refused to acknowledge the purchaser as the new owner of the vessel. Now, admittedly, whilst these occurrences were not everyday occurrences, they were becoming uncomfortably regular. And when these problems did arise, they caused chaos. They caused tremendous problems in the proper running of a vessel. Voyages got interrupted, charters were suspended, delivery of cargoes delayed. Owners found themselves having to put up security simply to get the ships freed from what was an illegal arrest for the sake of getting their vessel back on track, and then fighting the arrest later. So can you imagine the disruption? There you are, a purchaser in a judicial sale, thinking you've bought a ship free and unencumbered, and 6 months later it gets arrested by an old creditor. So you've fully loaded, you've got to get to your port of discharge. So what you do is you put up security and then you fight later. The time, the expense, the money, chaos. So there was also a fear that it would result in potential purchasers being very wary of judicial sales, leading to a loss of confidence in such sales. And that was a vicious circle, because if you have purchasers who are going to keep back, mortgagees, banks are going to be a bit, skeptical about lending for the purchase in a judicial sale. That would lead to less people bidding in judicial sales. It would lead to inferior prices. It would lead to less money in the pot. So the creditors would have less money to share at the end and after the judicial sale. So bad news all around. So what was the action taken? An international working group was formed. Loads of questionnaires sent out all over the world, and you see the whole CMI family providing information as to what was going on in the various jurisdictions. And eventually, the CMI produced a draft in 2012 in Beijing, which, and hence the name, the Beijing Convention, which was really, though, formally adopted in 2014 in Hamburg. Now, the next step, so we have the convention. So the next step was to find the convention a home. And off we go, trot off to the IMO and say, you know, here we are with a convention, would you be interested in it? However, the legal committee, 103 then, had doubts about it. They felt it was too private a law for them to get involved, and they said, you know, perhaps later. Well, we weren't particularly keen on the perhaps later. So we went to the Hague Conference on Private International Law, which was working at the time on the Convention on Recognition and Enforcement of Foreign Judgments. However, it was held then that perhaps this particular subject matter was more within the remit of UNCITRAL, the United Nations Commission for International Trade Law. And so the CMI made its proposal at the 50th session of the Commission at UNCITRAL in 2017. And the Commission heard this proposal and didn't say, no, we're not interested. What the Commission said then was, look, we are interested. However, why don't you hold a colloquium between now and the next session somewhere? Gather all the industry, see what they think about it, and come back and report. Now, that didn't leave us with much time. And that is where Malta and I actually got involved in this project for the first time, because we managed to organize the CMI, the government of Malta, and the Malta Maritime Law Association, I was president of the association then, organized this colloquium the following February 2018. And we had over 170 delegates from over 60 countries, representing a cross-section of the international maritime industry. Bankers, insurers, flag administrations, ship repairers, shipbuilders, tug operators, the ITF, people representing crew, BIMCO. Panelists and attendees examined the problems associated with the failure to give effect to the free and unencumbered title in vessels sold and judicial sales, as well as possible solutions. And they all agreed that we needed a solution, because people weren't sufficiently aware of how chaotic the situation was when these occasions arose. All of this, at the end of the day, would lead to great uncertainty. Mortgagees would be very reluctant to lend, as I've said. Purchasers wouldn't buy, leading to an inferior price. And that was bad news all round. So the conclusions drawn by the colloquium included the fact that there was a very real need for the convention. So off we go to the next session with the results of the colloquium in hand, which were presented by the Swiss government, because when you go to the Commission, the proposal needs to be made by a state member of UNCITRAL. And so it was presented as a draft of the Swiss government, and it was presented as a proposal of the government of Switzerland for possible future work on cross-border issues related to the judicial sales of ships. And that is where I first attended together with Stuart Hedrington, and I was given the opportunity to take the floor and to explain, by sheer coincidence, I mean fate, a situation that had developed in Malta only 2 weeks before that very session. Because what I really learned at the time, and carried that forward with me for the next 3 years, was that nothing moves an audience more than a real life story. And I told them, you know, these are the facts that have been reproduced. These are the statistics. But, you know, as we speak, there is a ship in Malta under arrest by a previous creditor. The vessel had been sold in a judicial sale 6 months earlier in Jamaica, free and unencumbered, 6 months earlier. And she happened to be passing by Malta, picking up bunkers, fully loaded with a cargo of wheat from Kafkas to Venezuela. She wasn't even in a Maltese harbor. She was in Maltese territorial waters where she stopped off to bunker. And the previous creditor arrested her. Total illegal arrest. But we couldn't simply say, hey, this is an illegal arrest because this ship is free and unencumbered and you can't do that. we had to put up security to get the vessel back on track. We had to put up about $1 million in security. And we spent the following 3 years fighting what was an illegal arrest. We won. We won the first court and we won the Court of Appeal. But it took 3 years of money from Steamship Mutual and 87 separate proceedings in order to get that ship released. So going back to so I explained all of this to the session, and that session decided to support the convention and take it on as an UNCITRAL work. And UNCITRAL works by appointing the project to a working group. And the working group allocated, to which our work was allocated, was Working Group 6. And Working Group 6 deliberated the convention from May 2019 to February 2020. UNCITRAL meets twice a year, once in New York and once in Vienna. Now, in the meantime, our National Maritime Law Associations, members of the CMI, worked really hard in encouraging their governments to request the attendance of maritime law experts as part of the state delegations, because what we need to understand is once you are in the room at UNCITRAL, it's all state representatives, and they are all highly accomplished, normally, foreign affairs dignitaries, ambassadors, but very few know the details of maritime law. Even suggesting that you can arrest a ship for a claim against a ship drew some pretty serious looks from the audience. So after the first session, we realized we had to do something about it. So we encouraged our NMLAs to encourage their governments to appoint maritime lawyers to be part of the delegation so we could have a proper discussion on maritime law. Now, Working Group 6 completed this article-by-article review and approved a final draft in June of 2022 in New York at its 55th session. And from there, what the Commission does, once it approves the article-by-article review and has a complete draft, it would then send it on to the General Assembly of the United Nations for adoption. And on the 8th of December 2022, the United Nations Information Service of Vienna announced in a press release that on the 7th of December, the United Nations General Assembly adopted the United Nations Convention on the International Effects of Judicial Sales of Ships. And the General Assembly authorized a signing ceremony for the convention to be held as soon as practicable in 2023 in Beijing, and recommended the convention to be known as the Beijing Convention on Judicial Sales. But more importantly, the actual United Nations General Assembly declaration states as follows. In most states, courts have the authority to order the sale of a ship to satisfy a claim that is brought against the ship or ship owner. Such a claim is typically brought to foreclose a ship mortgage in the event of default in repayment, or to enforce a maritime lien against the ship. The judicial sale procedure is typically preceded by the arrest of the ship. While the international community has achieved significant progress in harmonizing rules on the arrest of ships, much less progress has been achieved in harmonizing rules on the judicial sale of ships, which remain subject to widely varying domestic laws. And the Beijing Convention will enhance legal certainty by creating a uniform regime for the international effects of judicial sales of ships. So, as you can imagine, I had a great big smile on my face on the 8th of December of 2022. I still do, in fact, that's 2 years later. So on the 5th of September 2023, we all tootle off to Beijing to a magnificent signing ceremony, Beijing style, and 15 countries signed the convention. China, Burkina Faso, Comoros, El Salvador, Grenada, Honduras, Kiribati, Liberia, very important flag state, Sao Tome and Principe, Saudi Arabia, Senegal, Syria, Sierra Leone, Singapore, and Switzerland. And as you can see, there isn't one single EU member state. Why? Because the EU had not yet finalized by then its internal processes to allow EU member states to sign the convention. They did that 2 months later, on the 21st of September 2023. They finalized all their processes, which enabled even the EU itself now to sign the convention. And in fact, in March, just a couple of months later, the EU itself and Belgium signed the convention at UN New York headquarters. In the meantime, Ecuador and Tanzania also signed the convention. And Belgium was followed by Luxembourg. So by March 2024, we had 20 signatory states to this convention. Now, given the ability now for EU member states, now EU member states were now free to sign the convention. And there were a number of EU member states who thought, oh gosh, wouldn't it be a good idea to organize perhaps a second signing ceremony? But that was a big no-no, we understood, because the treaty book, which is kept at the UN building in New York, only goes out once to the country originally designated to be the signing country, which was Beijing. However, we Maltese, we push and push and push and push. And so the CMI, UNCITRAL, and the Maltese government came together, and it was decided and graciously accepted by the United Nations to allow the treaty book out of the UN building to come to Malta for a second signing ceremony. And that was held on the 19th of June of last year, 2024, where these countries then signed up: Malta, Italy, Spain, Cyprus, Croatia, Antigua, Barbuda, and Côte d'Ivoire. And it was a very, very special signing ceremony held at a magnificent palace called Verdala Castle, which was one of the castles of the Knights of St. John, 1600. But what was most important was that at the signing ceremony, we had represented the highest possible representatives of UNCITRAL, the IMO, and the European Union. And I must admit that just seeing all of these persons there, all together and backing a convention, gave the CMI a tremendous sense of satisfaction. And I addressed that gathering as the president of the CMI, and I concluded my presentation then by saying, the Convention on the International Effect of Judicial Sales of Ships is like a brand new 27,000 TEU container ship. Her construction drawings and plans are the draft by the CMI. She was built by a robust shipyard, UNCITRAL. She is now fully loaded. Enable us to discharge her at her discharge port by providing a speedy ratification process. Because as we all know, it's all very well and good to sign a convention, but it's pretty useless until you ratify it. So we were there encouraging the next step, which is ratification. As of now, the treaty, the convention has been signed by 31 states. 31 states, and it has been ratified by El Salvador. And another thing we managed to pull off at UNCITRAL is that it will come into force on the on the ratification of the third country. Now, as students, you would say, hang on a minute, 3 countries, don't you normally need 10 or 15 or 20? We really deliberated this at UNCITRAL during the drafting, and it was felt that it was good to keep the number low, because if we kept the number low, it was felt that other countries would be encouraged to ratify a convention which was already in force. Whereas, you know, recent trends have shown that countries are delaying in ratifying because they feel that the convention is never going to come into force anyway. Whereas with 3, that's a real achievable number. The convention. Now, Martin, we started a bit late. So does that mean I have some few more minutes? Thank you. So the convention has been acclaimed and praised for its brevity and straightforward style. It contains only 23 articles, and we believe that its simplicity and minimalistic approach will be the key to its success. How one goes about arresting the ship to secure your claim, the actual merits of the various claims leading to the judicial sales, how creditors will rank after in a competition of creditors' processes are not issues dealt with this convention, because the CMI acknowledged very early on that the grounds upon which you can arrest, what the merits are, etc. Those are so specific to particular jurisdictional rules that we would never have gotten consensus if we went anywhere near there. So the convention lays down the minimum criteria which should be satisfied so that when a vessel is sold free and unencumbered, it is perfectly logical for state parties to give proper effect to such a judicial sale. The entire focus of the convention is contained in Article 6, which provides for the international effects of a judicial sale, and it states, and I quote, "A judicial sale for which a certificate of judicial sale, as referred to in Article 5, has been issued, shall have the effect in every other state party of conferring clean title to the ship on the purchaser." So what does the convention provide? It provides that the convention only applies if the judicial sale is conducted in a state party and the ship is physically within the territory of the state of judicial sale at the time of the sale. It provides the minimum criteria for a notice to be given on a number of recipients. It provides for the Court of Judicial Sale to issue the certificate of judicial sale attesting to the fact that the criteria in the convention have been satisfied and that the law of the state of judicial sale has been satisfied. It provides that on presentation of the certificate of judicial sale, that is it, on presentation of the certificate, the registrar of the vessel's flag must delete the vessel and/or delete the previous mortgages and liens, and/or must effect the transfer of the vessel to the new owner. It provides that a vessel cannot be rearrested for previous debt, and if it is, it must be released. And it provides that the courts of the state of judicial sale shall have exclusive jurisdiction to hear any claim or application to avoid a judicial sale of a ship conducted in that state that confers clean title to the ship or to suspend its effects. Now, as I said, the convention has 23 articles, and the 23 articles put into more eloquent language what I've just said. Now, what I would like to share with you to conclude would be some interesting anecdotes of the procedures and the proceedings and what happened during the deliberation. One issue was the notice provision. And throughout the various sessions, there were a number of instances where the subject matter was really the subject of intense deliberation. And the notice provision, as we had originally outlined it in Article 5, was one of these instances. Because, as I said earlier, there were a number of delegates in that room that didn't have a shipping background. So they started to come up with all sorts of reasons why the entire planet should receive the notice of judicial sale. Now, we all know in this room that the people who need to receive the notice of the judicial sale is the owner, the mortgagee, the registry, the bareboat charterer, and the people immediately involved, and those claimants who would have shown an interest. But that was really difficult to convince. It was very difficult to convince these people. And so what we decided was that there and then, we knew that this was going to be a stumbling block. So unless we thought out of the box, we were going to get stuck. So we suddenly thought, wouldn't it be a great idea if one of the recipients of the notice would be some authority to which everybody had access? And immediately one thinks of the IMO. And immediately one thinks of the GISIS platform. I don't know whether all of you are familiar with the GISIS platform. What is the GISIS platform? The GISIS platform is a platform which is available on the IMO website, which provides information on a 24/7 basis. It is available from your phones. Anybody, anywhere with a smartphone has access to the GISIS platform. So we thought, look, why don't we make, as one of the recipients of this notice of judicial sale, the IMO. So the minute there is the notification of the judicial sale and the certificate of judicial sale to the IMO can put it up on its GISIS platform, and anybody from anywhere in the world can see whether a vessel is going to be sold in a judicial sale. And that satisfied the room, as I learnt the delegates are called, the room. So as a result, a new article was drafted, Article 11, which provides for the repository. This article provides that both the notices of judicial sale as well as the certificates of judicial sale must be sent to the repository. And during our deliberations, there was consensus that it would be the IMO. So at the Legal Committee 107 in December 2020, the same legal committee that had said, we're not too keen about the convention, this was a perfect opportunity to reintroduce the IMO, because by then, the IMO Legal Committee had realized that perhaps they had been a bit too rash in perhaps passing on our convention. So it was a perfect opportunity for the IMO to be present in the convention and to see the coming together of two very powerful UN institutions come together for the good of international maritime law. And in fact, it was at that session that I represented the CMI and said that the CMI wholly supports this idea and is of the firm view that this would be a perfect opportunity for two UN organs, such as the International Maritime Organization and UNCITRAL, to provide a solution to a matter which has such important ramifications and effects on international maritime law. So Article 11 now provides that all notices of judicial sales and certificates of judicial sales need to be sent to the IMO. Another important issue. As I have tried to explain, the entire raison d'etre of the convention is to achieve certainty and uniformity. So the provisions are very clear in that if a certificate of judicial sale is produced, a state party must give effect. The vessel must be released. The registrar must delete. The registrar must register. All very, no wiggle room whatsoever. However, again, during the deliberations, lots of delegations, well, not lots, that's exaggerating, a significant number of delegations said, but hang on a minute, what if there's fraud in the judicial sale? What if there is bad intent? What if there is wrongdoing? We must have exceptions to these rules. Now, as far as the CMI was concerned, our position was that we needed to be very careful if we were going to start introducing exceptions, because we would ruin and lose the entire focus of the convention. And there was much deliberation, and finally, with a view to reaching a sensible consensus and compromise, the working group decided on the exception of public policy, an exception and standard commonly found in other conventions. However, the clear understanding was and had to be that this exception of public policy had to be used really sparingly. And in fact, the convention reads manifestly contrary to public policy. And this was further explained by the explanation given by the Secretariat in paragraph 212 of the UNCITRAL Secretariat's explanatory notes on the Convention. And the Secretariat's explanatory notes on the Convention, which capture what was intended, states this: this sets a high threshold, which reflects recent treaty practice. The threshold is designed to avoid an abusive or overly expansive application of the public policy exception and requires a compelling reason as to why giving effect to a foreign judicial sale is contrary to an identified matter of public policy. It emphasizes that the public policy is expected to apply only in exceptional circumstances. Another twist to the norm was that, when we as CMI turned up at every meeting, well, after the first meeting, actually, when I saw hundreds of delegates from all over the world and a 23-articled convention, I thought, how are we going to make this room focus? We're going to be all over the place. This is going to take 20 years, because everybody told me I would have retired. After 10 years, perhaps we'd have a convention. So what we decided to do was, as CMI, was highlight important clauses and circulate our notes before the sessions so which could possibly assist the delegations to focus. And we called them the CMI notes, and those two were, quite useful. However, during the various debates and deliberations, as the debates and deliberations were going on, there would be entire explanations as to why it would be of benefit to have X wording instead of Y wording. And so the delegations asked the Secretariat whether they would, after the treaty was adopted, whether the Secretariat would actually publish their explanatory notes on the meaning, or well, not quite the meaning, on the proper interpretation of the clauses. And that is what they did. They issued the explanatory notes, and the explanatory notes are available on the UNCITRAL website. And of course, the explanatory notes will give the judiciary, with all due respect to the judiciary, guidance and, good pointers. Another thing that we were very fortunate about was the fact that we had an excellent chair and an excellent and a highly experienced UNCITRAL principal legal officer. Because what we did learn, what I certainly learned, because this was all new to me and it was an incredible learning experience, was that much of the progress depended on the discipline and intelligence and sharpness and experience of the chair as well as the legal officer. The chair was Professor Beata Cervenka from Germany, and the principal legal officer was Jose Angelo Estrella Faria, who, as the various deliberations progressed, and you can imagine, because even the room would be composed of different countries, as I said, and on a number of occasions, the discussion went beyond the strict law, went beyond judicial sales, and you could see countries positioning themselves from a political perspective. And when that was happening, and we, who are not at all political, would look around and say, what on earth is going on, where did judicial sales go to? The Secretariat would take a pause, and he would come up with his offering of a solution to alternative wording. And because it was being suggested by such an impartial person, that wording would be accepted. So he was fundamental and crucial in providing wording on the basis of which we could reach a consensus. Most importantly was the outreach. During the sessions, in between the sessions, it was fundamental that we had the support of the room, because the room would be made up of states, but it would also be made up of industry. Industry being the IBA, the ICS, the International Group of P&I Clubs, BIMCO. And I saw with my very eyes how the mood of a room can change from disagreeing with a proposal to agreeing with a proposal, depending on the amount of people who pressed the buttons and buzzers and spoke in favor of your proposal. And so the industry, which of course really wants this convention, was very vociferous, and the industry voices really assisted in swinging the room. COVID, and I will end very soon. Now, in the middle of all of this, we had COVID, and the UN stopped, except Working Group 6. So notwithstanding the fact that our first meeting was in December 2019, this convention was adopted in 2022. And the only reason why that occurred is that Working Group 6 did not suspend its work, but the work went online onto the Interprefy platform, which was an entire week of virtual meetings, because the meeting at Working Group 6 was for an entire week, which meant, of course, that in a number of cases, people who were homing in on the Interprefy platform would be having to work in the middle of the night, because the session would obviously be aired in the working time of the jurisdiction. So it would either be Eastern time or it would be CET. But we still pulled it through. So whilst most projects stopped, ours persevered. Conclusion. I hope that this has given you some insight into the work of the Comité Maritime International, and what it is that we do in order to bring uniformity in international maritime law. It would be amiss, however, if I were to bring this lecture to an end without paying tribute to one of our most important members, and that is the US MLA and its several successive presidents and members who have contributed significantly to the work of the CMI, including Chet Cooper, Vincent Deorkis, Michael Sturley, David Farrell, Barbara Holland, all in connection with the Rotterdam Rules, Frank Nolan and his work on our judicial sales project. Frank Nolan was the maritime law expert with the US delegation. And when everybody would be arguing, Frank would say, now hang on a minute. This is what happens on the ground. So he was really, really supportive. Of course, we have had a CMI past president, Chris Davies, who comes from New Orleans. And I would, of course, like to thank very much indeed the current president of the USMLA, Grady Sturley, also from New Orleans, for his continued strong and unflinching support to the CMI. So I hope all of this has whet your appetite. I hope you will all become members of the USMLA or members of the maritime law associations from the different countries you come from. And I hope that this has really encouraged you to believe that as practitioners, as academics, we have a very important role in achieving uniformity of international maritime law. Thank you, dear Martin, Professor Martin Davis. Thank you, Tulane, and thank you for your presence and for listening to me.
Well, I think not even Bill Tetley would find something negative to say about that. Are there any questions? Anybody would like? I have a feeling that Anne has answered them all. Yes?
IMO has this new rules on, CO2 emissions, especially for gas power and engine power reduction in the and we have a lot of difficulty, especially in the Mississippi in the river, where we have the jelly-like, substances and things like that. So reduction to 50% is really challenging for a lot of ships. So do you have any kind of advocacy position for that, or
Look, this is always a very difficult situation, because what you are talking about is the technical, scientific angle of the subject. Now, the IMO has got a technical committee and it has a legal committee. The CMI, being a law association, limits itself to things related to maritime law, which is why our main focus, of course, is the legal committee. However, as practitioners, so as CMI as an organization, we don't have the human resources, and B, it's not really within our competence to get involved in the in whether or not the limits imposed by the IMO are right, are correct. But I'll tell you something. The limits imposed, well, the limits which are being discussed at IMO and implemented by IMO are even more favorable to ship owners than the current plans within the European Union. The European Union are much stronger. Now, I think as far as whether it's the EU or whether it's the IMO, I think we're caught, the entire world is caught between the knowledge that we've got to do something about our gas emissions and ensuring that we don't deal too heavy a blow on the carriage of goods. Because at the end of the day, shipping carries 90% of world trade. So I think that, the IMO is very aware of this. I repeat, this is something that's dealt with in the technical committee. But as far as the legal impact of all of this is concerned, we try to see whether or not any of the technical side has got any legal implications, which is why we were encouraged to look at the liability issues in the case of the decarbonization efforts and the carriage of non-fossil fuels. That probably hasn't answered your question, but the end result is that as CMI per se, we don't get involved in the scientific and in the technical side of IMO regulation. We're just not the right forum. There's probably engineers that do that. Thank you.
Any other questions?
Yes, there's a lady. Well, and lithium, etc. No, not well, not that I know of. Now, let me think hard before I answer that question. I don't think so. I don't think so. The only committee we have at the moment which deals with the environment is the decarbonization and liability. I don't think so. However, it is likely that the latest paper which the CMI has produced in conjunction with the Australian government at the IMO, which deals with the liability for non-fossil fuels. Now, batteries would probably would probably classify as a fuel, of course, not in the literal sense. It could very well be that we're dealing with that from a liability issue, because the whole scope of that paper is to deal with the liability of ship owners when they're not either carrying or burning fossil fuels. But if you would like to leave your details with Professor Davies, I'll be able to follow that up with you.
Anybody else?
Yes.
Is there any realistic being ratified by the United States? Anybody even try?
Our convention? Well, one of the reasons, well, when we're in the United States, we will call it the Convention on the International Effects of Judicial Sales of Ships. Now, the United States, I'll never forget her. Her name was Sheila Dramel from the Department of Justice, accompanied by Frank Nolan. And the United States took a real keen interest in this convention. And one of the reasons why we kept it simple and uncomplicated was to encourage states which generally don't ratify the conventions. And yes, it's a known fact that the United States doesn't very frequently ratify conventions. So we're living in hope that the United States would sign this convention, particularly because so much US-owned tonnage is registered in the Marshall Islands and in Liberia. Now, Liberia has already signed the convention and it will ratify. Panama and Marshall Islands are about to sign any minute. Singapore has already signed and will ratify. Malta has signed and ratified. Now, you would think, why is she mentioning Malta? Because Malta is the 5th largest flag in the world. We've got over 110 million tons registered. So I believe that once so many important flag states have signed and ratified this convention, flag states with whom so much US beneficial-owned tonnage is registered, then it's in the interest of US ship owners that the United States ratifies this convention.
Anybody else? Well, if not, thank you very much, Anne.
Thank you.
Thank you.